I think we'll take the questions at the end after the second.
I will say, as I may need you to tell me now. Okay. Oh no, we're good. As I sort of, and again, this is even shorter than the last one, I promise. But what I wanted to say as I'm sort of setting it up is, so far I think we've been generous to prosecutors actually in saying that they are confused and that they may be making mistakes. I am quite certain that in some cases that is true. But I am just as certain that in other cases prosecutors are very well aware of the difference between fact and fiction and are exploiting it nevertheless. I just wanted to add that. Okay. So I want to talk about, and this was something that Andrea mentioned in her talk, about a new type of case that we're seeing. And it's hard for me to say, I don't want to say new in the sense that the very first case just emerged. We're still trying to sort of trace these. But this new case, and I mentioned it as well, is not where rap is being used to provide evidence of a defendant's role in some underlying crime, or even to show a connection to gangs and so forth. Those are still by far the most common uses of rap as evidence. But what we're seeing now is a new type of case in which the rap lyrics themselves are the crime. In other words, the lyrics themselves are prosecuted generally as terrorist threats, and people are being prosecuted regularly. This was something that even a few years ago when I started investigating these cases, I didn't see very many of. So when Andrea said it's been the last couple of years, that sounds right. That certainly, I know the calls that I'm getting from attorneys, which are frequent, are more and more regularly asking for help in these threats cases. And I've testified, I've only actually had to testify in one in federal court recently that if I have a chance to talk about, I will. But no doubt the most high-profile example was one that the U.S. Supreme Court heard last year, and that was Alanis v. United States. And this is just a graphic of an amicus brief that we were asked to write, that Charis Cooper and I were asked to write to submit to the Supreme Court once they agreed to hear it. Now, I won't go into all of the details, but basically, this is a guy who gets on Facebook. He's mad because his wife is leaving him, and he starts writing all kinds of threatening sounding messages to Facebook. Now, he doesn't tag her, they're not friends, but it's Facebook. So once somebody else sees it and the word gets out, okay, she learns of it. The issue is that many of the lyrics were styled in the form of rap lyrics. And he claimed, and believably so, that these were influenced by artists like Eminem. Okay? Eminem, who, for example, openly threatens his wife Kim by name over and over, right? He gets Grammys and millions of dollars. This guy gets an FBI visit. Essentially, but the issue that, so ultimately he was prosecuted. And he was prosecuted not only for threatening his wife, but ultimately for threatening a female FBI agent who came to visit him. And with one of the lyrics was after she came to the house to sort of check on things to see what was going on, he wrote, he posted to Facebook, "Little agent lady stood so close, took all the strength I had not to turn the bitch ghost." That's a good way to end up in federal court, and he did. He was found guilty of I think 5 out of 6 counts, all of them threats-based. And this started to go up through the appeal system and eventually reached the Supreme Court. The question there was fairly narrow. It was what speech actually rises to the level of a true threat, because the First Amendment protects your speech, but there are certain categories of speech that are not protected, one of them being true threats. So how do you determine whether or not speech rises to the level of a true threat? The problem is that across the US, different courts were applying different standards. Some courts were saying that a true threat, in order to determine whether or not something rises to the level of a true threat, you have to determine whether a reasonable person would have viewed that as a threat. I think it's a little more complicated than that, but I'm close, right? Yeah. And that's it. Other courts were saying, no, you have to also take into account, or you have to take into account a person's intent, their subjective intent, or what they meant when they did it. And so we came in to write this supporting the defendant, Alanis. Now, this is not a good guy. He did have a history of domestic violence, so he wasn't much of a rapper, right? He suddenly went to rap when he was mad at his wife, but it's not like he has a history of producing videos. So the facts were not wonderful. But our point was a simple one. It's that context matters, and that's why I thought that your quote at the very beginning was absolutely germane to this conversation. It's context, but it's also, what is a reasonable person? A reasonable person is unlikely to be a female, is unlikely to be a person of color, right? Generally speaking, I think when we talk about a hypothetical reasonable person, we're thinking, or at least it works out that way, what a hypothetical white middle-class guy would think. And when that runs into rap lyrics, we have these problems. Now, ultimately, I won't dwell on Alanis. Ultimately, the court heard the case, and in a very sort of narrow, not all that helpful decision, did nevertheless rule that intent was critical to enforcing the federal statute that involved true threats. How close did I come?
Quite.
Okay.
Quite close. Good.
Yeah.
Yes.
So it only applies to cases in federal court. It's not going to really help us in the states, and they didn't take on the broader First Amendment implications that we were hoping they would, even though we knew realistically they might not. Alanis is kind of an aberration because it involves a white guy who isn't really a rapper, but who's using rap and is being prosecuted for it. More often, we're seeing young men of color, okay, who find themselves in these situations as well. This is actually what was sort of the catalyst for my collaboration with Sharis Kubrin at UC Irvine. This was a college student. His car ran out of gas on campus. He parked it on the side of the road, and the authorities investigated, right? There's a car, abandoned car, and they found wedged in between the two seats a little piece of paper, a scrap of paper. And on it, on one side, they had all of these, right, it's actually, I think, on some sort of like prescription pad or something. He's got all of these lyrics, and they're in rhyme form on the left. But the problem was on the right, there was some prose, not verse anymore. And I've sort of blown that up a little bit, but it was, if this account doesn't reach $50,000 in the next 7 days, then a murderous rampage similar to the VT Virginia Tech shooting will occur at another highly populated university. This is not a joke, right? Now, he was prosecuted, okay? And he didn't have a criminal record other than that. And my colleague Sharis was called in as an expert, and it turns out that this guy was absolutely, and is still, an aspiring rapper. He was a compulsive note taker. Right? Some rappers claim that they don't write any of their lyrics down, right? Jay-Z claims that. Others, you can tell that they probably actually don't. I mean, their lyrics are bad. This guy was the opposite. He had piles of notebooks in his house, and this is what we see a lot of in these cases. Which makes it very easy, by the way, for prosecutors to cherry pick because they can just go through hundreds of pages. Eventually, you'll find a lyric that maps to something in that crime. But in any case, she went through, and what she found is that he had this penchant for unrhymed intros and outros, which are very common in rap music, right? You think of the skits in an NWA song, any number of Biggie songs, right? That's very common. And she got on the stand and said, look, this is absolutely a pattern of his authorship. This is how he works. And this is very common in the genre. The violent stuff, you know, because there were some violent lyrics in there. She explained in terms of genre convention, all of that. The all-white jury didn't buy it, and he was sentenced to, I want to say, 6 years. He served just over a year until the Illinois Supreme Court overturned it on unrelated legal grounds. Okay, it wasn't related to the rap lyric issue. We're seeing more cases like this with young people too. I won't go into so much detail. This guy, don't get me wrong, a lot of these cases involve stupid choices. I mean, we have to acknowledge that some of the things people are doing are dumb. This is an example. This kid, who by the way aspired to attend Juilliard, is a bona fide musician who didn't have a discipline problem in school. Nevertheless, posted a song called Columbine. Okay, never a good idea, though, hey, Eminem raps about it too. Grammys for him. He wrote about it. He named some of the staff, the school staff, by name. And he was charged with making a terrorist threat. Now, ultimately, there was some legal nuance to it. He was 17 when he posted it, but 18 when the police talked to him. They wanted to charge him as an adult, and so it actually hinged on a verb tense that he used during the conversation with the police. Because if he had put it in the past tense, then all of it was when he was 17. But if he used present tense, they could get him at 18. It went to juvenile, okay? So, and so he's not ultimately facing anything serious. Nevertheless, we're seeing cases like this all the time. And I think what you said about grime is particularly relevant in these threats cases because they all draw on, or many of them draw on, the battle rap tradition, which employs highly violent rhetoric and oftentimes singles out other people by name. In battle rap, you know, to beat somebody is to body bag them, right? I mean, that's a violent term. That's the common terminology. To kill somebody is to do it lyrically. But if you're not familiar with that context, to go back to your quote, you don't know that, and it becomes very easy to view these as threats. It becomes even easier to view them as threats when there are actual murderous rampages going on involving people who didn't write rap lyrics, but God forbid you miss one. And rap makes it very easy for prosecutors to make that case because they're already both drawing on, and I would argue perpetuating, these enduring stereotypes about the inherent violence of black men anyway, who again are the overwhelming majority of defendants in these cases. Sorry, that was going to be for Colin. Colin, that was for you, that was for Rick Ross. Just to show you the contrast between the two, about what people say they are and what they actually are. There's one more that we're looking at now, and this isn't in the judicial process, in the criminal justice system. Well, I guess it is, it's sort of now. And this is Taylor Bell. We're going to be writing another amicus brief for the Supreme Court, again dealing with rap music. Because there was a young man named Taylor Bell, apparently a stand-up guy. His only disciplinary issue was a tardy once. He, at one point, it turns out that a couple of the coaches at the school were known for inappropriate conduct towards female students. So he, while off school grounds, posted a song, and I believe there was a YouTube video as well, in which he named the coaches by name, used some violent rhetoric, but was ultimately standing up for a couple of friends of his, a couple of girls who had claimed that they were being harassed. So he was using this in clearly political ways. He was trying to stand up against what he saw as an injustice. And what happened was, without any investigation into the legitimacy of his claims, he was summarily expelled. And so this has now gone to an appeals court. The appeals court at first ruled that he was wrongfully expelled, and Andrew, you've got to correct me anytime I get this wrong. But this decision was a narrow set of justices, and appeals courts, if they don't like what some of their colleagues did, to quote you, can have the whole appeals court hear it. They did that. And then they reversed the initial decision. So in short, the expulsion stands. And so we are pushing the Supreme Court to hear this case and to understand, at least our role will be to help them understand it in terms of rap lyrics. The concerning thing, though, is that I know for a fact we're going to see more and more and more of these cases. It's just become too easy. And it's even in cases where these young men are parroting, if not directly quoting, well-known songs like Fuck the Police. That's the example over there. It was a riff on a well-known protest song, right? Even as artists like Ice Cube in their songs have singled out individual police officers by name and said, if I see them, I'm going to kill them, right? He becomes platinum selling, right? These guys are going to jail. These are genre conventions, but they are genre conventions that get very complicated to explain, especially if you're in an expert role, and they become even more difficult to explain in a broader context of gun violence, in which everybody is sort of operating under this level of fear. It becomes very difficult, I think, for jurors to do the analytical work when it's much easier to just send them away and not risk anything. This is what I see as probably the future of the sort of rap-on trial. I still see the continuation of all of this, particularly the gang trend, but this is what we're seeing now, and this is what I expect to continue to grow, especially as social media facilitates these types of things. And that's become central, as you noted too, in the dissemination of crime. So that's all I have for you for now. I think I'd love to talk, hear what everybody else has to say.
Right, thanks very much. Well, any questions on either of those very interesting presentations?